Hello, everyone. How's it going? This is immigration attorney Moumita. I'm coming to you live to talk to you about immigration and to see the questions that you may have on your mind tonight. Thank you so much for joining me. It is my pleasure to be here to talk to you about immigration and to set your mind at ease regarding the variety of things that may be troubling you or worrying you about your immigration status or about your immigration case. So if you do have a question or something you'd like to share, you can put it in the comment box below, and I'll do my best to get to everything that is being asked of me during the time that I have for today. But for those of you who are joining me for the first time, welcome to my live. My name is Moumita Rahman. I am an immigration attorney, and I have been practicing immigration law for the past 13 years. And it is my pleasure to do the work that I do because I believe that immigrants make America great already and that you deserve a place here and to have your voice heard and to be counted for. So if you do need an appointment with us, give us a call at 212-248-7907 to make an appointment with a member of my legal team to see how we can help you move forward in your immigration journey with peace of mind and with security. So today, the question that I want to start off this live is, what are the types of evidence that you can use in your VAWA case? What are the ways that you can prove that you have suffered abuse in your marriage to a U.S. citizen or at the hands of your adult U.S. citizen children? How can you actually prove these things when nobody has ever seen you go through what you've gone through? No one may have witnessed it, or you think that it is simply not something that an immigration officer will believe. Let's talk about this for mainly to dispel the myth that a lot of people have, that a lot of other immigration attorneys themselves have told you is true. But this is a myth. The myth that exists out there that is perpetuated by a lot of lawyers down to persons being, basically, this is something that a lot of lawyers also say to people who want to file for VAWA, which ends up discouraging them from filing for VAWA. And that is this. The myth is that you need to have proof of physical abuse or a police report or a medical report. You need to have pictures. The myth is that you cannot win your VAWA case without these things. And it is simply not true for two main reasons. The two reasons why this is not true is, number one, underneath VAWA, you can prove either what is called extreme cruelty or battery. Extreme cruelty is the emotional abuse that you would suffer as an immigrant. As an immigrant, one of the ways that people can try to keep control over you is mainly because of the fact that they'll use fear of you losing your status, fear of you getting deported, fear of getting in trouble with the police as a way of keeping control of you in your marriage or in your relationship with a U.S. citizen. Now, so you can show extreme cruelty or battery. So you can't, by logic, have a medical report or police report if somebody is only psychologically abusing you. But the second thing is that the main source of evidence that can help you win your VAWA case is actually you. And you can have all the evidence in the world, but if you don't have a good affidavit to support what happened, to explain what happened in your marriage, then your case will not be successful. So the main source of evidence that you need in your VAWA case is actually you. And you need to have a well-written, well-explained affidavit, which is what we help our clients with. It's the majority of our work. We help craft really, really strong affidavits. We do hours-long interviews with our clients to get to the details of what happened. And then we help explain it through the affidavit so that an immigration officer can see it and at first glance not have any questions about what happened, okay? But what are some other ways that you can help prove your case if you're filing for VAWA? And number one is witnesses. You can have so many types of witnesses in your life, and you don't need to have a witness letter that talks about everything that happened. But let's say, for example, you talk about a small thing that happened in your marriage, and one of your coworkers saw evidence of it. They saw your husband or your wife show up at work looking for you, or they know that you constantly get called on the phone, and you might rush to leave work at a certain time or get back home by a certain time. That's evidence that can be written about in an affidavit, for example. Second is, text messages and emails and call logs, screenshots, pictures. These are all types of evidences that you can use to support what's happened in your marriage. But again, the key is to talk about things that, to show little pieces of support, little pieces of corroboration of your case. The next thing is if you have ever had, to replace anything, if you've ever had to buy something like your spouse breaks your phone, or you have to get a wall patched up, or you've had to buy lots of presents, there are sorts of receipts that you can show. Okay, so the bottom line is that there are actually lots of different ways that you can show evidence in your case, but the most important piece of evidence is actually you and the affidavit that is submitted in your case to help show what happened, okay? So I don't want you to be worried that you don't have enough evidence in your VAWA case. You probably have a lot more than you think. And one of the things that we do as part of our work is to work with clients during the interview process to pinpoint the types of evidence that we can help show to support the case, to help the client win. And it's not rocket science. It's not unobtainable. The law is written in a way that helps explain why you might not have a lot of evidence, because the government knows that getting evidence in your type of situation is actually more difficult than not. So they give you that little bit of leniency, and they also have a special legal standard, which is for any credible evidence in your case, okay? Any credible evidence. All right, so that is what I wanted to talk about today. And the other question that I had is clients wanted to know how long does it take if you file for a VAWA? So if you file for a VAWA, your case is going to take roughly 2.5 years to 3 years, or possibly even more, because the VAWA case takes a long time because of the backlog that immigration is now experiencing. But you have to consider that the VAWA case is about 2 parts. The first part is the VAWA application, which is decided by the Vermont Service Center, and that by itself can take an average of 1.5 years to about 2.5 years to process. And then once that is processed and approved, then your case gets forwarded to your local field office for the green card portion of your case, or the adjustment of status portion. And that will, the good news is that in our office, we've been seeing many sorts of, almost every single VAWA application of ours has been approved for a green card without an interview. So the immigration offices are definitely waiving a lot of green card interviews. But, if you do end up having an interview, probably it would take at least another year or more, depending on your local jurisdiction, okay? So if you have any questions, go ahead and pop them in the box below. I'm going to go ahead and answer some questions live. I have a question from Akwasi, and also thank you for your continued patience. I am live streaming on 4 different platforms, on TikTok, YouTube, and Facebook, as well as Instagram. So thank you for your patience, and I appreciate you giving me a little time to get to your question. So from Akwasi is saying, I filed my VAWA case with adjustment of status 5 weeks ago, and USCIS has still not cashed my check. So Akwasi, that's actually normal. I would say it takes about 2 months to 3 months sometimes for USCIS to cash checks when you file something, and they are taking a little bit of a long time to give receipts in your cases. So I would say average, give USCIS about 2 to 3 months to give you receipts for your case. Liz is asking, my dad was caught twice but never arrested. Can I sponsor him? From Liz. Liz, thank you so much for your question. So here's the thing, Liz. What was your father caught for, and what status is he? How did he enter the U.S.? So if he was caught twice while trying to enter the U.S., that means that most likely he may have an entry without inspection. Or if you were caught at the border, you might even have something called an expedited removal order. And if you are looking, if your child is looking to sponsor you and you were caught at the border, then the chances are pretty high that your child, you as the son or the daughter of an immigrant may not be able to sponsor your parent as easily as other people might. And for your parent, especially if your parent has been caught more than once at the border, then we have to look to see what other solutions your parent might have. Because typically, if you have more than one illegal entry, then it's going to create some sort of complication in your case. So we have to look to see if you qualify for a variety of cases. So give us a call, Liz, at 212-248-7907. And if you missed my last live, I talked about what are the various options if you have something called a permanent bar, or if you just simply have an illegal entry. Here's the good news. If you are a parent and you have an adult U.S. citizen child, but you entered the country illegally and you are having a very difficult relationship with your child, your U.S. citizen child, acts very ugly towards you. They don't respect you. They're always rebelling. They're always yelling at you, threatening you, getting mad at you. Maybe they drink and do drugs and get in trouble all the time, and you have to bail them out, or they get aggressive at home. If you entered without permission into the U.S. and you have an adult U.S. citizen child that treats you this way, then you may be eligible to file for VAWA and get your green card in the U.S. without having to leave the U.S., even if you have an illegal entry. And the best part is that this would not affect your child. Many people want to know, will filing for VAWA affect my child? And the answer is no. Filing for VAWA will not harm your son. It will not harm your daughter. It will not go on their public record. It is simply a way for you to get security and to get status inside the U.S. without having to leave. So call us at 212-248-7907 to see if we can help you with that. Thank you for the follows. Let's see. Got a lot of requests from Instagram. From Official is asking, I filed for VAWA since December 2019, and up until now, no decision has been made in my case. Can I file a lawsuit on a USCIS for this reason? From Official OFK. So Official OFK, you can file whatever lawsuits you want. However, the official processing time for VAWAs is still, if you filed in 2019, then it might be outside of the processing time. So the key is for you to check what the average processing time is right now. And if your case is outside of that window of time that USCIS says is the normal processing time, then yes, you can file a writ of mandamus, which is a lawsuit essentially against USCIS to try to force them to make a decision, okay? Good luck with that. My mother has 2 entries, one with a visa, 2 through the border. 23 years ago, can she get the green card without leaving? From Warley Lino. Warley Lino, thank you for that. So if your mom has a one entry with a visa and 1 entry through the border, the most important question that I would need to ask, that we would need to ask your mom, is when did you leave and for how long were you in the US and when did you come back? Because we have to calculate to see if your mother has something called the permanent bar. Now, if your mom has a permanent bar, then there are 3 types of cases that we look at to help parents of US citizens get a green card even with a permanent bar. And number 1 is for VAWA, but this is a little bit more complicated because if your mom has a permanent bar, then we have to see whether that entry or that exit is connected to any abuse she suffered at the hands of her U.S. citizen children. Or second, we can look to see if your mom qualifies for the T visa or the U visa. Now, the T visa is something that is actually a really effective way for helping people get status, even if they have the permanent bar, even if they have a deportation order, even if they have a variety of immigration problems, because with the T visa, we can essentially waive a lot of things. And what is the T visa? Well, the T visa is sadly more applicable to our parents than we think, because our parents have been in this country for a long time, for 30 years, for 20 years, and they have no doubt worked for at least one employer who has mistreated them. And when you have a situation where your employer, you're an undocumented immigrant and the employer that you work for discriminates against you, is racist, is abusive verbally, or they don't pay you, they force you to do all sorts of things, they just do not treat you in a manner that is fair and dignified, then usually that is the basis, that can be the basis of something called the T visa. And we would love to see if your mom qualifies for anything. So Warley, give us a call, 212-248-7907. Jesus is asking if I'm married. Yes, I've been married for 13 years. Are you serving in Dallas or Cleveland? From Marawanium. Yes. So here's the thing, guys. Even though I'm based in New York, we work with immigration clients all over the U.S. It simply does not matter where you live, because as an immigration lawyer, we are working in an area that is federal law. And that being said, I don't need to limit the work that I do to just New York State, where I'm licensed, but I can practice in any immigration court in the US. I could file applications with any immigration office because it's a federal law. And most importantly, the more important thing is actually the fact that the way that we work at this law firm, we have a really large team and we are virtual. We work virtually with a lot of clients. We have a New York office where our attorneys and our paralegals are here, but we have a large virtual team and we work virtually with our clients to make sure that they get their immigration cases filed quickly and fast and effectively. And we work through Zoom, through phone, and through a secure online portal that helps make our messaging with our clients in one location. And it allows us to work effectively and efficiently no matter where the client is located. So even if you're not in New York, if you're in Dallas or Cleveland, give us a call at 212-248-7907. Hi, Mohammed. Arshad, how are you? MK's asking, dear attorney, the initial consultation for brand new client is not directly with you anymore, but the question is, whoever I will be consulting with, will they be the same and knowledgeable as you? From MK. MK, thank you for that question. I definitely understand that this way of doing a case evaluation with our office, which is it will not be with me, it will be with my legal team. They are as knowledgeable as me because I am the one that trains them, and I give my legal team my knowledge and I teach them every single week. We have trainings. I do Moumita's law classes with my team as often as I can. And whenever my legal team does not know something, they ask me and I'm still overseeing them and answering their questions. And if there's ever a problem, then I also step in, but I'm watching what's going on. So even I want you to feel confident, MK, that whoever you're speaking with, as long as they're a part of my team, they will have the knowledge and they will know how to help you. And everything gets run by me anyway. So I want you to feel confident about that. And just give us a call at 212-248-7907. I am 45 and divorced, and my mom wants to file for my green card. Am I allowed to apply for adjustment of status? From Melissa Mongru. Melissa Mongru, if your mom is a U.S. citizen and wants to apply for you, if you're in the U.S., you need to be in legal status in order to do adjustment of status, and you need to be able to maintain status until your mom's application for you becomes current, which takes about 15 to 20 years sometimes. So you may not be able to do adjustment of status. You may need to go back home to wait for consular processing. Adjustment of status may not be an option for you, but you can call us to see if you qualify for anything else that does not involve your a petition by your mom. And this is a question that I get from a lot of clients is, you might have a brother or a sister or a parent who's a citizen, and you're already in the U.S. and you want to find out whether your brother or sister or your mom or dad can petition for you, even though you're an adult and you're maybe married or divorced, whatever it is, right? And there's two things that you have to look at for that. Number one is whether you are a preference category relative. And if you're an adult child of a U.S. citizen, or it's your sibling that's applying, then your application is governed by something called the visa bulletin. And the visa bulletin is going to tell you the estimated amount of time it takes for your application to become current. So for adult children of U.S. citizens, that could be 10 years, 12 years. And if you are already inside the United States and you want to apply for a green card, there's two things that have to be true. Number one, your status cannot be expired. And number two, you cannot have unlawful presence. So if you're going to be able to be in the U.S. on a work visa for 15 years when your parents applied, then that may be possible. And it may mean that you can adjust your status in the U.S., but frequently that's not really the case for most people. And I would say you might have to do a waiver or go outside to do, you may have to go outside the US and do a waiver for unlawful presence, okay? Give us a call, 212-248-7907. Junior, you're very welcome. Vaibhav Gaba is asking, good evening, attorney. Is it safe to travel to India on advanced parole while adjustment of status is pending? From Vaibhav Gaba. Vaibhav, I would say anyone who wants to travel on advanced parole. If you want to travel on advanced parole, you need to talk to your attorney first and make sure that you don't have any problems in your case that might get triggered when you travel. And second, there's definitely at least one airport that I do not recommend you travel through, which is Chicago. I think Chicago Airport, we see a lot of problems for our clients coming through because the CBP there is aggressive in a different way that is not nice. So you can usually travel, but you have to check with your attorney. How long is affirmative asylum taking? From Johnny. Johnny, affirmative asylums can take anywhere from 2 months to 6-7 years at this point. It's very, very unpredictable. You know, USCIS asylum offices are still instituting something called the last in, first out rule, but it's not being employed consistently because we file lots of asylums and sometimes we get our interviews within 1 month or 2 months, and sometimes we're still waiting years to get our interviews. But generally speaking, as a rule of thumb, if your asylum was filed for any time before 2000, I would say 2018, you're probably going to be waiting years for an asylum interview. Wancho is saying, I applied for a waiver, but my lawyer said that once the waiver is approved, I have to leave the country to get my documentation. What can I do to get my documents here instead? I love this question because there are many of you who are you're doing a waiver process, which means that you will need to leave the United States to get your green card. And my priority is to first look to see whatever we can do for our clients that does not require them to leave the US, even if they would need a waiver, even if they have an illegal entry or unlawful presence. And Wancho, what I would say is that if you're doing a waiver, it's probably because it's based on marriage to a US citizen or to a green card holder. And the reality is that the waiver process takes 4, 5, sometimes 6 years even, especially if you're from Mexico, it's taking a long time. And during this time, you might be going through a lot of problems in your marriage, problems that you might feel like are normal, but in reality, they hurt you a lot, they harm you a lot emotionally, and you're suffering in your marriage. And I would say, why don't you give us a call at 212-248-7907, because based upon what's happening, you know, maybe you're even separated from your spouse during all this time. Maybe we can help you apply for something called a self-petition, which does not require you to leave the US. You do not need to, you would also get a work permit. We can even possibly help you get a travel document, and it would not hurt your spouse or require you to separate, but we have to check to see what's been happening in your relationship. But here are some common problems that we have seen with our clients, and they've gotten approved for their green cards this way. Number one, if your spouse is a very jealous type, if your spouse doesn't like you talking to other people, they get mad at you if they see you looking at another woman or talking to a waitress or anything like that, they don't want you to talk to your family or go out with your friends. Your spouse is always telling you that you're good for nothing, that you're inútil, that you don't earn enough money, that you're a bad father or a bad parent, and that you can't do anything right. And lastly, if your spouse ever makes you feel like because they're the ones helping you get your papers and you're not good enough, or that you owe them for a lot of things just because they're helping you get your papers, these are usually signs that you may be eligible for this self-petition called VAWA, and you should really give us a call to explore this option because, number one, you do not need to leave the U.S. to do this case, okay? Who wants to leave the U.S., right? It's risky. Who knows how long it'll take? There's no guarantee that you'll get approved once you're outside. And while you're doing this case, it says that, you're stuck inside the U.S. still without a work permit for so long. And if these things are happening in your marriage, Juancho, give us a call, 212-248-7907 to see if we can help you, okay? Rifanisha, hello. Rifanisha is asking, what happens if you file for VAWA and receive a request for evidence from your previous marriage case and still have not gotten the VAWA receipt? Rifanisha, so what would happen in that case is a lot of our clients come to us after having already filed for a marriage case with their spouse, but things obviously may not be working out and it is a serious struggle to stay in the marriage. So what happens if you decide to file your own self-petition while your I-130 or your I-485 with your spouse is still pending, and after you start the VAWA case, you get a request for evidence on your I-130 or on your I-485 that you filed before you filed for VAWA. So what we do in our office is if we get a request for evidence on a client's I-130, the thing is that the I-130 is actually owned. It is technically owned by your U.S. citizen spouse. So we would not respond on that behalf. However, most of the times we would let the field office know and attach to your I-485 case and let them know that we filed for VAWA if we get a request for evidence on your I-485. And even if we don't have the receipts in your case yet, we show them proof that it was filed, and we let them know to contact the Vermont Service Center to coordinate about that. Because the purpose of that, Rifanisha, is we would try to save your I-485 case to get it to keep it from getting denied. The I-130 is one thing, but the I-485, we try to keep that open so that you don't have to pay that fee a second time. It sometimes works, it sometimes doesn't, and even if the I-485 gets denied, we write to them, we tell the field office like, no, look, guys, we filed for VAWA, and we're asking for you to reopen this case because there's a VAWA that's been filed, or we notified you about the VAWA being filed. And I would say the majority of the times, actually, we are able to get cases reopened that way. But if you have filed an I-130 with your spouse and then you file for VAWA and you get an RFE on your I-130, that is technically your spouse's I-130 RFE and you can't do much about it. But you can respond to RFEs on your I-485 and you can let your field office know that you're filing for VAWA and ask them to give you time to file for VAWA and not deny the I-485, okay? Medusa Sol is asking, do you do payment? I call, but I'm not sure I can afford. Medusa, give us a call. We do evaluate cases on a case-by-case basis, okay? MK wants to know what part of Bangladesh I'm hailing from. Well, I will answer this because I think I have some Bangladeshi clients that are watching. আপনারা যদি বাংলায় কথা বলতে চান, আমি বাংলা পড়তে পারি না কিন্তু বাংলা বলতে পারি, so you can write out a question in English and I'll try to respond to it in Bangla if you want. And as far as what part of Bangladesh I'm from, আমরা ঢাকার থেকে, okay? What is the time frame in Virginia for green card through marriage? My case is being actively reviewed after 60 days. Do I get to receive social security number and work authorization from Abdul Rahman? Abdul Rahman, there are a lot of immigration offices throughout the U.S. that process their cases really, really fast. So for example, in places like Virginia, we've had approvals come through really fast over there. And sometimes when you have a really, really fast field office that's working on your green card case, your green card gets approved before even your work permit gets approved. But what will happen is that if your green card gets approved before your work permit, you don't need a work permit anymore, but you may have a little bit of a delay in your social security number being issued. Once you get your green card issued, you can take it to the Social Security office and apply for a new work permit or for a replacement. And you have to see what they say over there in order to get your actual Social Security card. From John is asking, do you use the therapy evaluation in all cases or is it not always necessary? Thanks. Great question, John. So believe it or not, we do not do psychological evaluations for every single case. And we've gotten actually the majority of our cases approved without a psych eval. In the past, I used to require all of my clients to do psych evals But then I learned that it's actually not even necessary, and we have not gotten it done in a lot of cases. But sometimes if we do get a request for evidence, then we will encourage clients to do a psychological evaluation at that time, because that's the time when you really want to make even more of an effort to get your case pushed through. So for nowadays, these days, we don't really do a psych eval unless I think it's necessary, or we get a request for evidence. Does a T visa need to have an interview? The restaurant I was working in is already closed, but open in different name, but the same owner is working there. Is this a problem to apply for a T visa? From Jalisa. Jalisa, thank you for your question. So the thing about the T visa is that even, one of the requirements for a T visa is that we need to report what happened to some sort of law enforcement agency. And this could be the Department of Labor, this could be the police station, this could be FBI. There's many different types of law enforcement agencies that we can do a report of, but there's no, but the majority of places that we've reported to don't always require an interview. And it's also meant to be confidential, so I don't want you to worry about that, Jalisa. But when you report what happened in your situation, in your case, if it was you were working for, if you were working for a restaurant, then normally what we would do is we would report it to the Department of Labor in your state, because it's a labor-related trafficking situation. And when it's a labor-related trafficking situation, we report to the Department of Labor. It really boils down to whether that specific office thinks that your violation occurred within a certain time frame, and whether there's a statute of limitations that has not yet finished in your case, and whether they want to investigate. We've only had investigations in some cases, but the only requirement is to cooperate with them. And even if they ask for an interview, it's not something that you can't handle, and that we are present with our clients at all times as well. So even if that restaurant is also closed, that still doesn't matter. There's no requirement in the T visa statute that the employer that you used to work for is still alive, even, or even in operation. So Jalissa, if you're in that situation and this has been worrying you, give us a call at 212-248-7907. Let's see. Let's see what other questions I have. I got a social security number. I've been in the US 4 times. How can I start my case if I decide to move to the US and say I'm from Serbia, from Petar? And anyone else who's looking to move to the US. If you're looking to move to the US and you want to stay here, there's 3 main categories through which you can ask for permission to stay here. One is because of a family-based petition. So you need to have a spouse or a parent or a child who's a US citizen or a green card holder basically try to petition for you. The second is through employment. So if you have an employer who is ready and willing to sponsor you, you can see if there's some sort of visa you qualify for and apply through that. And then the third main category is something called humanitarian applications, such as asylum applications, T visas, U visas. So all of these usually require for you to have gone through some sort of persecution or trauma to qualify to apply and stay in the US. So if you're looking to come here, these are the 3 main ways. And people want to know all the time, is there any way that I can get a work permit when I come here on my tourist visa? And the answer is not really. If you're just coming here on a tourist visa and you want to stay here, you cannot just automatically apply for a work permit. Rather, you need to qualify within one of these 3 broad categories to apply for something, and then maybe you might be able to apply for a work permit after that. But the only way to find out what you qualify for is to do an evaluation. You can give us a call at 212-248-7907. We don't take every type of case, and if we can't work with you, we'll tell you. Miss Unique is saying, my friend's husband left her and now her interview is coming up. Can she close the case and do VAWA instead from Kiss Unique? Kiss Unique, absolutely. This is one of the most common situations that our clients go through. A lot of our clients have started their case with their spouse, and the spouse, abandons them or refuses to go to the interview, and then the interview is coming up, and now you're stuck trying to figure out what to do. And if you're in that situation where you have started a green card case with your spouse, but your husband or your wife left you, or you're separated, or you're divorced, or they just simply will not show up to the interview, call us today at 212-248-7907, because now is the time to take action to try to save your case. You can file for VAWA even if your case is pending right now. In those situations, time is of the essence so that your I-485 does not get denied, and we notify the office that we're going to file for VAWA and ask them to hold your case open and not deny it right away. So there are many steps that we have to take, and if you are in that situation where you have an upcoming immigration interview and your spouse is not going to come with you, call us today at 212-248-7907. Let's see. From Linda Manai is asking, my husband does not want to continue my petition and he is forcing me to sign a postnuptial. Also, he is being very harsh on my son, but I have very little evidence for my VAWA except for some text messages from Linda. Linda Banai, please write this number down, 212-248-7907. I want you to call us today, because there are many ways that your spouse can be hurting you right now. Definitely, it sounds like he's probably using some emotional tactics, some psychological tactics to try to pressure you to sign this postnuptial agreement. And, especially if you come into a marriage to a U.S. citizen and your child is with you, right? One of the worst things as a parent is to see your child getting hurt by the person that you marry, right? It is really, really heartbreaking to witness your child be yelled at, be treated like not even like let's say the person you marry also has children, and you could see visibly that your American spouse treats your child like a second-class citizen. That is abuse. That is emotional abuse. And if you're going through that, your spouse is threatening to divorce you, pressuring you to sign a postnuptial agreement, call us today at 212-248-7907, because you likely qualify for VAWA. We'd love to ask you some more questions to see what we can do for you and for your child. So call us at 212-248-7907. I've been married to my wife 7 years. She's been here 18 years, but she doesn't remember the days that she got 2 or 3 illegal entries. They never made her sign. Can she still get a green card? From Johnny Canado. Good question. Are you married to somebody? Is your spouse someone who's been here for many years? They came through the border many times, and you don't know if they ever got a removal order or not. Can they qualify for anything? And Johnny, I would say we need to ask your wife some more questions to see what she qualifies for, because just because somebody has multiple entries at the border does not always mean they have the permanent bar. But we do have to be careful and ask questions to see what your spouse qualifies for. So call us at 212-248-7907 so that we can make an appointment with your spouse. How long does it take to get a combo card in VAWA? I would say it's taking about 8 to 10 months. Let's see. Bricky Malays, my husband applied for advanced parole. But I received a letter where the lawyer filed for VAWA. What is it? That's something that is probably between your husband and his attorney. But VAWA is the Violence Against Women's Act. Okay. Miss Kiss Unique, thank you for liking the live. All right. Is it also okay if my spouse lives in a different state while I send paperwork for their green card? From Island Girl. Island girl, this is a good question. Can you live in a state different from your spouse and file for a green card at the same time? The answer is yes. However, you need to do things very, very carefully because immigration does not like for you and your spouse to be living in different states. When you apply for a green card, to them, it's like a sign of fraud and a sign that something is not right. So you have to have a good, number one, if you and your spouse do not live in the same state or the same house and you are filing for a joint green card application, there's two things that you have to show. One is why you are not living together. There has to be a good reason why you're not living in the same house. And second is you need to have lots and lots more proof to show that your marriage is a bona fide marriage and that you married in good faith, okay? It can be done. We have gotten clients approved even where they did not live together, but it's a little bit more work. And there were valid reasons, such as for, like, let's say one of the spouses was in university or in the military or had to travel to take care of a sick parent. So there has to be a good reason for that, okay? All right, guys, that's all the time that I have for today. Thank you so much for joining me. I just want to see if, let me do another last question from Vena Musinger, who's saying, I have been married for 6 years. I got kicked out of the house over 5 years ago. Am I able to get VAWA from Venom Mousinger? So the answer is possibly yes. You know, if you're, so here's one thing that we see a lot, you know, if you're an undocumented immigrant and you're married to an American and you're getting kicked out of your house when you get into an argument, when they're mad at you, you're being left to sleep on the street or in your car. This, for me, is abuse because it's dangerous, number one. And if your spouse is willingly putting you into that situation, there's usually more things that are happening. So if your American spouse has been kicking you out of the house and you don't have a green card, this may be the basis for you to file for a VAWA application. But what happens if you separated 5 years ago? Can you still file for VAWA? And the answer is that it depends on whether you are still legally married to your spouse. Just because you're separated does not always mean that you're actually divorced. If you're actually divorced, then we have to look to see when your divorce happened. If your divorce happens within the past 2 years, then we could still file for VAWA. But if it happened before 2 years ago, then we have to look to see if you qualify for something else, okay? So call us at 212-248-7907 if you want to see what your options are, okay? I hope everyone has a great night. God bless. I will see you guys here again, hopefully soon. And if you need an appointment, call us at 212-248-7907, and I'll see you soon. Bye. Take care.